afternoon program in the Hall of Philosophy. Before we get started, I want you to know that this afternoon's guest, Jeffrey Toobin, will be signing copies of his most recent best-selling book, The 9 Inside the Secret World of the Supreme Court, immediately after his presentation here in the Hall of Philosophy. This afternoon's program is in partnership with the Robert H. Jackson Center. In just a moment, you will be hearing from John Barrett, the Elizabeth S. Lennay Fellow at the Jackson Center. Mr. Barrett is a graduate of Georgetown University and the Harvard Law School. He teaches law at St. John's University. He is the editor of That Man, an Insider's Portrait of Franklin D. Roosevelt, Justice Jackson's previously unknown memoir of FDR and the New Deal. The book was recently published in paperback by Oxford University Press. Mr. Barrett is currently working on a biography of Justice Jackson, which will provide the first insider's account of his year away from the Supreme Court, serving as chief American prosecutor at the International Military Tribunal in Nuremberg. Ladies and gentlemen, please join me in welcoming John Barrett.
Thank you very much, Sebi. Good afternoon, and welcome to Chautauqua Institution's 4th Annual Robert H. Jackson Lecture. The topic of this lecture series is the Supreme Court of the United States, a central institution in our government, and we believe, all of us, and we believe correctly, in our lives. Just 2 weeks ago, the Supreme Court concluded its most recent term and began a recess that will last until the first Monday in October. This summer moment, and of course, this Chautauqua setting for serious reflection, is thus fitting for consideration of the Supreme Court of today and the Supreme Court of tomorrow. The Jackson Lecture is named for Justice Robert H. Jackson, who served on the Supreme Court from 1941 until his death in 1954. Before he went to Washington, D.C. in 1934 to serve in the Roosevelt administration, rising to become Solicitor General, then Attorney General, then Supreme Court Justice, and in addition, Chief Prosecutor at Nuremberg of the principal Nazi war criminals, Robert Jackson was a Jamestown, New York, and Chautauqua County lawyer. He was, in particular, and throughout his life, a Chautauquan. He regularly visited these grounds, and he spoke frequently from these platforms, including literally this one. Robert Jackson lived one of the most interesting, permanently consequential lives in our country's history. His achievements and his eloquent words continue to shape United States and international law. Today's Supreme Court justices, along with many, many others, study, invoke, and revere Justice Jackson's words and his example. The Robert H. Jackson Center in Jamestown, which proudly co-sponsors today's lecture, commemorates and educates here and around the world regarding Justice Jackson's contributions. And Chautauqua Institution fittingly recognizes Jackson and its connection to him through this lecture series. Today's Jackson lecturer, Jeffrey Toobin, builds on a great tradition. In 2005, Professor Jeffrey Stone of the University of Chicago, in the inaugural Jackson lecture, discussed the Supreme Court and freedom of speech in wartime across history and today. In 2006, Linda Greenhouse, the great New York Times Supreme Court reporter, delivered a Jackson lecture here that surveyed the court's work from her special vantage point and expertise and considered the changes that can occur and have occurred in individual justices, including Harry Blackmun, William Rehnquist, and Robert Jackson, during their years of service on the court. Last July, Seth Waxman, an attorney in Washington and a former Solicitor General of the United States, previewed in his Jackson lecture here the argument that he subsequently delivered last December to the Supreme Court concerning the rights of detainees at Guantanamo to federal court habeas corpus review, a case that he won 5-4 on June 12th of this year. And so you, as the moot court, all deserve credit for assisting him. Jeffrey Toobin, today's lecturer, is one of today's very finest reporters, writers, and legal and political commentators. He's an honors graduate of Harvard College and Harvard Law School, a former law clerk to Judge J. Edward Lombard of the United States Court of Appeals for the Second Circuit, and a former federal prosecutor, including in the Eastern District of New York. He is a staff writer, that most unassuming, impressive title in the world of journalism and really arts and letters, for the New Yorker magazine. and he is senior correspondent at CNN. Jeff's current book, The Nine, Inside the Secret World of the Supreme Court, is brilliant reporting and beautiful writing about the Supreme Court. This is not merely a personal view. The reviewers, from popular to scholarly, agree, and the book was on the New York Times bestseller list for over 4 months, which I find heartening because of the book's quality and because the Supreme Court truly matters. The court raises and addresses some of our toughest questions, beginning with issues of its own role and reaching issues of our very lives. Robert Jackson, of course, knew this thoroughly, intimately, as a Supreme Court advocate and then from the inside as a justice. One glimpse of this Jackson knowledge from his deeply reflective mind and skilled pen is found in a few sentences that Justice Jackson penned privately to a friend in spring 1950, as Jackson and his fellow justices were wrestling with early cases concerning the constitutionality of racial segregation in public schools. Jackson lamented in 1950 what he viewed as a history of the Supreme Court taking an unjustified judicial control over social and economic affairs. He disapproved generally of, quote, a majority out of 9 appointed life tenure justices settling such issues. Jackson noted that a great many people abandon the so-called judicial restraint position and think that, quote, the court should decide such questions provided it will decide their way. The problem in my mind, Jackson wrote 58 years ago, is not merely should we 9 decide this case, but should such an institution decide such questions for this nation? I'm not sure that very many of today's Supreme Court justices share those Jacksonian questions and implicit views. I quote them nonetheless because they are important and because they include, clairvoyantly, Jackson's call to learn and think carefully about the 9. I am very pleased to introduce Chautauqua Institution's 2008 Robert H. Jackson Lecturer, the author of The 9, my friend, Jeffrey Toobin.
Thank you. Thank you, John. Thank you all for coming on this beautiful day in this beautiful setting. It's my first visit to the institution, and we're having a great time, and I appreciate you taking the time to join us this afternoon. Robert Jackson is a remarkable figure in American history for many reasons. He led, as John said, one of the consequential lives of the 20th century, and there are many things we could talk about. We could talk about the Jamestown lawyer that he was. We could talk about the New Dealer that he was. We could talk about his world-changing experience as the chief prosecutor in Nuremberg. But I'd just like to begin with a little tribute to Robert Jackson for another of his accomplishments, which is he was, I think, by common consensus, the best writer ever to serve as a Justice of the United States Supreme Court. To read the sentences he wrote, to read the eloquence with which he discussed the law is a true joy for anyone who appreciates such things. And I'd like to just start by telling a little story from Supreme Court history in which Jackson plays a key part. In 1940, there was a famous Supreme Court case named the Minnersville School District of Pennsylvania against Gobitis. And young Gobitis was a Jehovah's Witness whose family believed that that to salute the flag, to pledge allegiance, was a violation of their religious tenets. And young Gobitis was thrown out of school because he, true to his religious convictions, did not salute the flag, did not pledge allegiance, and his case challenging his expulsion went all the way to a Supreme Court. And in a decision on June 3rd, 1940, the Supreme Court upheld his expulsion. Now, think about the dates here. The dates are very important. June 3rd, 1940. It was the time, of course, of the beginning of World War II. France fell within a few weeks of that decision. And for a very rare occasion in Supreme Court history, nearly the identical case returned to the Supreme Court just 3 years later. in a case called West Virginia Board of Education versus Barnett. And the court had changed somewhat in its composition, and Robert Jackson had joined the court by that point, and Robert Jackson wrote the opinion. And the opinion, which I had the occasion to reread in preparation for this talk, is remarkable in its entirety, and it's hard to select out a couple of passages. But just to make the obvious point, this decision came out on June 14th, 1943. And the world looked very different in the United States in June of 1943. The world was embroiled, and the United States was now embroiled in World War II. And the outcome in the middle of 1943 was a far from a foregone conclusion. And Hitler, the enormity of Hitler's crimes were just starting to be known. And this is what Robert Jackson wrote, where, I should say, they reversed the decision in Gobaitis, and in the nearly identical case said you could not expel a young boy from a West Virginia school because his religious convictions said he couldn't salute the flag or pledge allegiance. They ruled the other way. And this is what Jackson said. Those who begin coercive elimination of dissent soon find themselves exterminating dissenters. Compulsory unification of opinion achieves only the unanimity of the graveyard. It seems trite but necessary to say that the First Amendment to our Constitution was designed to avoid these ends by avoiding these beginnings. Authority here is to be controlled by public opinion, not public opinion by authority. Pretty good, huh? And then in the most famous passage from the opinion, he wrote, if there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. If there are any circumstances which permit an exception, they do not now occur to us. Now I have to follow that with my words. It's pathetic. I apologize in advance. Now, he also said something else, which was in the nature of kind of a witticism. It was actually in a Supreme Court opinion, in a concurring opinion, and he had a description of the United States Supreme Court, which I think is, it's one I quote all the time, and as I think just about as good as any that has been given. And he wrote, we are not final because we are infallible. We are infallible only because we are final. Now, think about that. That sort of sums it all up right there. They are flawed, they are human, they are creatures of their time, but they're all we got. And they have the last word. And that's really why I wrote the Nine, because the court is really very much a mysterious institution, I think, even to well-educated citizens. People are aware of the 9 justices. I won't do a quiz, but some people can name all 9. It's pretty hard, I admit. And the justices themselves even have a little fun with the fact that they are simultaneously very much public figures, but very much unknown. And I'll give you an example. For reasons that remain obscure, David Souter and Stephen Breyer are frequently mistaken for each other. Now, if you know what they look like, they don't particularly look alike, but they are often mistaken for each other. So one time, not too long ago, David Souter, as he often does, was driving from Washington to his home in New Hampshire, and he stopped to get something to eat in a little restaurant in Massachusetts. And he's there, and a couple comes up to him, and the guy says, I know you, you're on the Supreme Court, right? And he says, yes. He says, you're Stephen Breyer, right? And Souter didn't want to embarrass the fellow in front of his wife, so he said, yeah, yes, I'm Stephen Breyer. And so they chatted for a little while, but then the guy had a question Souter didn't expect. He said, so Justice Breyer, what's the best thing about being on the Supreme Court? He paused and said, I'd have to say it's the privilege of serving with David Souter. Now, how can you not love an institution where that's still possible? But other than to capturing the hilarious hijinks of David Souter, there were other reasons I wrote the book. This is a key moment in the history of the court. And to see why it's a key moment, I think you need to go back to the late 60s. Because the late 60s was the last time the Supreme Court was really a unified ideological institution. The late Warren years, late years Chief Justice Earl Warren, the court had 7 liberals. Hard to believe, right? There were 7 liberals on the Supreme Court. And the court reflected not just individual liberal opinions, but there really was a liberal agenda at the court. And you saw it year after year. 1964, New York Times against Sullivan, expanding protections for the press in libel law. 1965, Griswold versus Connecticut, where they established the right to privacy and said that married couples could not be prevented from buying birth control. 1966, the Miranda Decision, which created a whole new way of looking at criminal procedure. And of course, in case after case, the Warren Court, usually unanimously, dragged the South, kicking and screaming, into the 20th century in all the civil rights cases. But then something quirky happened in the history of the court. 4 justices left in very quick succession, and Richard Nixon got to appoint all of their replacements. You never know what's going to happen with appointments. Jimmy Carter is the only president in American history to serve an entire term and not have one appointment to the Supreme Court. There were just no vacancies while he was president. But Richard Nixon got 4 appointments, and he was only president for 5.5 years. You'll recall he had to leave early. That was like in all the papers, I'm sure you remember. And Richard Nixon had 4 appointments. Warren Burger, just the 4 who left were Earl Warren, Abe Fortas, Hugo Black, and John Harlan, left in quick succession, and Richard Nixon got to name their replacements. And Nixon's replacements illustrate a theme that I try to talk about in the 9, and I think subsequently, which is the evolution of the Republican Party. Because the Republican Party of Richard Nixon was a very different institution from the Republican Party of George W. Bush. It was very much a more moderate party. It was not a party particularly concerned with social issues. It was a party that was an old-fashioned country club, Main Street Republican Party, and Nixon's appointments to the court reflected that. Who were they? Warren Burger, William Rehnquist, Harry Blackmun, and Lewis Powell. All of whom, Rehnquist was more conservative than the others, but the other 3 were definitely reflective of Nixon-style republicanism. And though many people thought the decisions of the 70s would start to swing way to the right, in fact they didn't. Many of the decisions of the 70s were just as liberal as those of the 60s. You had the approval of school busing. You had United States versus Nixon, the Nixon tapes case, where the justices essentially forced Nixon from office. And in still the most controversial decision of our lifetime, Roe versus Wade, 1972, where the court ruled by a 7-2 vote that a woman's right to choose abortion was protected by the Constitution. The only 2 dissenters in that case were William Rehnquist and Byron White, the Kennedy appointee. So 3 of the 4 Nixon justices were in the majority in Roe versus Wade. And I think that illustrates where the party was in the 70s. And the changes only really began with the election of Ronald Reagan, because Ronald Reagan brought with him to Washington a group of people who thought that, there has been a liberal agenda at the Supreme Court, but we need a conservative agenda for the court as well. And that group was led by Edwin Meese, who I understand is a Chautauquan. And he was the Attorney General for several years, and he brought with him a group of highly intelligent, charismatic, talented young conservative lawyers, and they started to build a movement. They started the Federalist Society. A lot of liberals today talk about the Federalist Society as if it's something out of the Da Vinci Code, that it's some scary secret organization. Something scary or secret about the Federalist Society. Conservatives decided in 1981 that they needed an organization where they could meet and talk about their ideas. And what were those ideas? expand executive power, end racial preferences intended to assist African Americans, speed up executions, welcome religion into the public sphere, and above all, reverse Roe versus Wade and allow states to ban abortion. But the Republican Party of Ronald Reagan was not the Republican Party of George W. Bush either. And you can see in Reagan's appointments to the court that while the conservative movement had gained ground, it was not nearly what it would become. And that begins in 1981. Because during the campaign of 1980, Ronald Reagan made a promise that Jimmy Carter didn't make. He said, if there's a vacancy, I will appoint a woman to the Supreme Court. He didn't say, I'll appoint a social conservative. He didn't say, I'll appoint someone who'll overturn Roe versus Wade. He said, I will appoint a woman. So when Potter Stewart unexpectedly announced his intention to resign in 1981, Reagan said to his people, find me a qualified woman. And they found Sandra Day O'Connor, who was hardly an obvious choice for the Supreme Court, not even from the highest court in the state of Arizona, from the Intermediate Appeals Court. But she had a lot of practical experience. She had been majority leader of the Arizona State Senate. She'd been a trial judge. She'd been a private lawyer. She was someone that Reagan thought projected his values onto the court, and she was nominated and confirmed. The other Reagan appointments to the court reflected the balance of a party that was moving to the right but not yet there. 1986, Warren Burger stepped down. Reagan named Rehnquist to be Chief Justice, named Antonin Scalia to fill that spot. The following year, little mutters, not some Scalia fans in this part over here. I don't know. The following year, a real turning point in the history of the court. Lewis Powell resigned. And Lewis Powell was someone who was a term that the justices don't like that we journalists use, but a useful term nonetheless. He was the swing vote. He determined the outcome of many important cases on abortion, on affirmative action, and his departure really left the court in a very precarious moment. And Ronald Reagan named Robert Bork to that seat. And for the only time in our lifetime, the country really had a national conversation about what the Constitution meant, because Robert Bork was a very distinguished, very eminent, and very conservative legal scholar. And he said that the Constitution does not protect a right to privacy. And he said that the Civil Rights Act was a monstrous thing. And in 1987, right after the 86 elections, where the Senate had tipped over back to the Democrats, the Senate voted him down, 58-42. They said, look, too conservative. That's not what we think the Constitution stands for. And Howard Baker, who was the White House Chief of Staff at the time, said to Ronald Reagan, look, we can't get someone that conservative through. Let's pick someone more moderate. Thus, Anthony Kennedy. So when people say Anthony Kennedy is some big surprise as a justice, that's not really accurate. He was picked because he was more moderate, because that's where Reagan was at that moment in his presidency. And that really set in place the Rehnquist Court, which is very much the subject of the Nine. And just a couple of things about the Rehnquist Court that you might not know. Now, I was inspired to write the Nine by a book that I'm sure many of you are familiar with called The Brethren by Bob Woodward and Scott Armstrong. Just a terrific book. It was published in 1979, a long time ago. And if you recall the theme of that book, the theme was how all the justices just couldn't stand Warren Burger. That there's all these personal animosities. And in the history of the court, that's more the rule than the exception. The justices historically have not gotten along very well. I don't know how many of you have the misfortune to have heard of a justice named James McReynolds, who served on the court from 1914 to 1941, who was such an appalling anti-Semite that he used to get up and leave the conference room when Justice Brandeis or Justice Cardozo would speak. William O. Douglas, the cantankerous liberal who served on the court for more than 3 decades, He used to spend his summers in rural Washington State, and one time in the 50s, he drove his car off a cliff. And one of the first questions everyone asked back at the Supreme Court was, where was Felix Frankfurter at the time? Because they hated each other so much. So as I started work on the Nine, I thought, great, I get to write about the hatreds of the Rehnquist years. But to my great disappointment as a journalist, I learned that William Rehnquist was a very popular figure on the court. William Rehnquist, by the way, who was a law clerk to Robert Jackson. Got to throw in as many Jackson references as possible here in Chautauqua. And Rehnquist really knew how to get along with his colleagues, and he was really revered across the political spectrum. One reason he was so popular was he engineered a tremendous reduction in the court's workload. The justices liked that a lot. In the 80s, the justices were deciding about 150 cases a year. By the time Rehnquist stepped down, they were deciding about 70 cases a year. Now do the math. 70 cases divided by 9 justices, divided by 4 law clerks apiece. It's a pretty good gig being on the Supreme Court. Now, in the 80s, the workload got so high at the Supreme Court that there was actually a proposal by Chief Justice Burger to create a new super appeals court right below the Supreme Court, and this to relieve the workload. And it went to the White House counsel's office for approval. Now, the White House counsel then was a lawyer named Fred Fielding. Weirdly enough, he's still the White House counsel. He assigned this, an evaluation of this idea to one of his young assistants, and that young assistant was named John Roberts. And this is what John Roberts wrote in a memo about that idea. While some of the tales of woe emanating from the court are enough to bring tears to the eyes, it is true that only Supreme Court justices and school children are expected to and do take the entire summer off. Now, I haven't heard Chief Justice Roberts talking that way much lately. The summers off grow on you very quickly. And the thing about John Roberts' court is that it remains a congenial place, the way it was under William Rehnquist. You can see that if you go to watch the court in action, go to watch an oral argument, which I certainly encourage you all to do. It's a very interesting and entertaining thing. And the best known fact about the Supreme Court and oral argument is that there are 8 justices who are highly engaged, highly prepared, full of questions for the lawyers who are arguing, and Clarence Thomas never asks any questions. Now, even by Thomas's remarkable standards, last year was extraordinary. Last year there were 104 oral arguments at the Supreme Court, and Clarence Thomas did not ask one question in one case. An enterprising reporter from the McClatchy newspapers counted up all the words spoken by all the justices in all the arguments that year. And Stephen Breyer was first with more than 35,000 words, and Clarence Thomas was last with 0. But if you go to see the justices in action, you will see that Thomas is not silent. He sits next to Breyer, sits next to Kennedy, he passes notes, he tells jokes, they tell jokes to each other, they get along. It is a court that gets along well with each other, including Thomas. And that is a part of this court. Now, in terms of the Rehnquist Court, I think it's useful to think of the court in 2 parts. From 1986 to 2000 and 2000 to 2005. Because then the dividing point in the history of the court, and in many ways the dividing point in the history of our country, is the decision in Bush v. Gore. Now, I admit to being somewhat obsessed by the decision in Bush v. Gore. There are 3 chapters in the Nine about it. I'm not going to talk a lot about it now, but my last book was a book called Too Close to Call about the recount in Florida, where, of course, I wrote a lot about Bush v. Gore as well. And one of the things I tried really hard to do in Too Close to Call for the research was to interview Al Gore. Obvious thing to do, right? So I tried everything, and he just absolutely wouldn't talk, didn't want to relive the experience, didn't want to talk. And just by coincidence, while I was working on the Nine, I met Al Gore at an event, and we started chatting, and he had read Too Close to Call, and we were talking about it, and I said, you know, Mr. Vice President, you'll never believe this, but I'm writing another book about Bush v. Gore, and, you know, I think I'm the biggest Bush v. Gore junkie in the world. And he said to me, you may be second, which I think, you know, I got to give him a nod on that, because his stake in the outcome was a little different than mine. But Bush v. Gore, I hope, is an interesting story in and of itself. I'm not going to go through it here. But what's especially important and interesting about the aftermath is the aftermath of Bush v. Gore, because Bush v. Gore had a transformative effect on the key member of that court, and that was Sandra Day O'Connor. O'Connor was, of course, part of the majority that essentially awarded the election to Bush. And, woo, pretty good, huh? And she thought that, again, in keeping with the theme of the changing Republican Party, she thought George W. Bush was going to be a Republican like his father, like her, a moderate Republican, a compassionate conservative, a Main Street Republican, libertarian Republican, Western Republican, Goldwater Republican. And George Bush, to O'Connor's eyes, did not turn out that way. Turned out to be very much more conservative. And you saw O'Connor react in her opinions to what she saw in the Bush administration. And look at the decisions from 2000 to 2005. They ended the death penalty for the mentally retarded. They ended the death penalty for juvenile offenders. They decided Lawrence v. Texas, the famous case that said states could no longer ban consensual sex among homosexuals. They saved affirmative action in Justice O'Connor's opinion in the University of Michigan Law School case. And then in case after case, they rejected the Bush administration's position about the detainees in Guantanamo, all from 2000 to 2005, all with Justice O'Connor in the majority. Why? She didn't like John Ashcroft. That was not her idea of a Republican. She didn't like the way the war on terror was being conducted. She didn't like the war in Iraq. And above all, O'Connor was affected by an event that doesn't get talked about a lot now, but an event that I think will loom large in the history of this decade, and that's the Terri Schiavo case. The Terri Schiavo case had a big impact on Justice O'Connor, in part because she was horrified by the way the Congress and the President were trying to push the judiciary around, and judicial independence meant a great deal to her. But there was also a personal dimension to her feelings, because she was just at that moment dealing with her husband's Alzheimer's disease. And the issue of medical decision-making for a disabled person was hardly abstract to Justice O'Connor in 2003, 2004. And in 2003, Justice O'Connor started bringing John O'Connor with her to court every day. And in 2004, John O'Connor started wandering away the way Alzheimer's patients sometimes do. And in 2005, O'Connor made the fateful and very much unexpected decision to leave the court. She went to her friend, her law school classmate, William Rehnquist, and said, I have to leave the court to take care of John. Note here parenthetically the question, how many male Supreme Court justices would have made that calculation? I don't know, but probably not many. But in any case, that was the calculation that O'Connor made. And here's where the chronology gets important and poignant. O'Connor announced her departure in June of 2005 upon the confirmation of her successor, and President Bush named John Roberts to replace her. All summer long, the confirmation hearings were planned, and then over Labor Day weekend, William Rehnquist died. Bush immediately named Roberts to replace Rehnquist. And so O'Connor had to wait while Roberts' hearings went forward and he was voted on. Then President Bush named Harriet Miers to replace O'Connor. Ah, yes. That tragicomedy took about a month to resolve itself. And then only then did President Bush name Samuel Alito. He was confirmed. There were hearings and he was confirmed. In all, it was nearly a year between O'Connor's intended departure and her actual departure from the court. And during that year, the court the court, John O'Connor slipped completely into the grip of Alzheimer's disease. And by the time O'Connor left the court, John no longer even recognized her. So simultaneously, Sandra O'Connor lost her beloved seat on the court and lost her beloved husband. And the court quickly became a very different place. And the court is now very much more conservative than it was. And we have seen that. It is a court with 4 strong conservatives, with Alito, Thomas, Roberts, and Scalia, and 4 pretty liberal justices, Souter, Stevens, Ginsburg, and Breyer, and Anthony Kennedy in the middle, deciding the outcome of case after case after case. And last term, not this term, but the term before, where the court struck down the desegregation plans in Louisville and Seattle, Justice Stephen Breyer said, "It is not often in law that so few have quickly undone so much." And I think that, from Stephen Breyer, is a very significant message. And if I may sort of anticipate a question, well, what happens now? Well, what's going to happen in the future of the Supreme Court? Well, we'll get to that. Just to get to that. Spirited group, that's what I like. The only factor that is relevant about the future of the Supreme Court is who wins the next election. That is the only variable that counts. Because, to answer your question, there are likely to be 3 vacancies in quick succession. John Stevens is 88, just celebrated his 88th birthday. Now, I hasten to add, his older brother, William Stevens, is still practicing law in Florida at the age of 91, but, 88 is 88. Justice Ginsburg is 75. Justice Souter is 69 and longs to return to New Hampshire. So 3 of the 4 liberals are likely to leave. Now, what happens if John McCain wins? Well, you said that, I didn't. Well, but we have a clue. We have a clue, a very important clue, because on May 6, John McCain gave a speech about the future of the Supreme Court as he sees it. And I think it's very significant, the date on which he gave it. Now, I'm sure it's hard to remember right now, but May 6th was the day of the Indiana and North Carolina Democratic primaries. It was the day that the Democratic nomination was really settled. And it was a day where the political attention of the country was pretty well focused on Indiana and North Carolina, and I think it is significant that McCain chose to give his speech on that day, because the Republican Party has, it appears to me, moved so far to the right so fast that it has left much of the American people behind right now, because this, when you see what McCain said and how he said it, you see that he is a smart enough politician to know that he can't say explicitly what he means about the Supreme Court, because the public, by and large, does not support what he wants to do on the Supreme Court. And I'd like to conclude by reading 2 excerpts from that speech and try to translate from the code in which it's written what he's really saying. The first excerpt. For decades now, some federal judges have taken it upon themselves to pronounce on rule on matters that were never intended to be heard in courts or decided by judges. With a presumption that would have amazed the framers of our Constitution and legal reasoning that would have mystified them, federal judges today issue rulings and opinions on policy questions that should be decided democratically. Now, what's he talking about there? Roe versus Wade, that's what he's talking about. He's saying if states want to ban abortion, the state legislature should be allowed to do it. But why doesn't he say, as he used to say, well, I'm just for overturning Roe versus Wade? Because the public doesn't want to see Roe versus Wade overturned. So he speaks in this code about policy questions being decided democratically, and the people who know, the people who he is trying to appeal to in the conservative movement, they say, oh, I know what he's talking about, but he doesn't come right out and say it. Now, the second excerpt is even more elliptical, if I may. Sometimes the express will of the voters is disregarded by federal judges, as in a 2005 case concerning an aggravated murder in the state of Missouri. As you might recall, the case inspired a Supreme Court opinion that left posterity with a lengthy discourse on international law, the constitutions of other nations, the meaning of life, and evolving standards of decency. These meditations were in the tradition of penumbras, emanations, and other airy constructs the Court has implied over the years as poor substitutes for clear and rigorous constitutional reasoning. The effect of that ruling in the Missouri case was familiar too. When it finally came to the point, the result was to reduce the penalty, disregard our Constitution, and brush off the standards of the people themselves and their elected representatives. Now, what's peculiar about that passage? It doesn't say what the case is about. Well, what was this case from Missouri? Well, the case was called Roper v. Simmons, and it was a case about a 17-year-old boy who was sentenced to be executed for murdering a neighbor. And Justice Kennedy wrote an opinion for the court that said, we are no longer going to execute children in the United States. And he wrote about the stark reality that the United States is the only country in the world that continues to give official sanction to the juvenile death penalty. Kennedy noted that the only country to execute juvenile offenders since 1990, besides the United States, were Iran, Pakistan, Saudi Arabia, Yemen, Nigeria, Congo, and China. And Justice Kennedy said, we are not going to be in that group anymore. And, you know, even in the United States, which is a pretty tough on crime country, it's not very popular to say you're in favor of executing children. But so McCain wrote in this very elliptical way about this opinion. But that's what the opinion was about, and that's what the stakes are in this election. And with that, I hope you have some questions. I suspect you do. Thank you very much. Thank you. There are microphones here on either side, and just help yourself. Yes, ma'am. I don't know if it's on. There you go.
Okay. First of all, I wanted to thank you for your wonderful speech, and also to say that Justice O'Connor did speak here a few years ago. I was not here, but I listened. I downloaded it online, and I was really mystified when she recommended that people read Jackson's opinions, and now I'm not. She just said they were brilliant and extremely well written, and so I was remembering that. My question has to do with this idea that certain decisions should rest with the people rather than with the judiciary. And I understand that this is a position that many conservatives take, and I'm wondering how they reconcile that philosophy if it shouldn't be the most basic decision left to the people rather than the courts. Who should be our president?
Okay, well, there's a little Bush v. Gore reference there, I tell you. Well, you know, the phrase that is often bandied about is judicial activism. You know, conservatives are supposed to be against judicial activism, and liberals are supposed to be for judicial activism. And, you know, the classic judicial judicial activism means when the court supersedes its own judgment for the judgment of elected officials. And, for example, in Roe v. Wade, the Supreme Court said, look, state legislators, you may want to ban abortion, but we're not going to let you do it. And that was, I think it is safe to say, judicial activism. But what about, you know, the city council of the District of Columbia, which says, you know, we think that the way to stop crime in our community is to ban the possession of handguns. Now, a conservative majority says, we know better, we are not going to let you do that, the Constitution forgives it. I think that that is a very stale debate. There are judicial activist decisions of the left, there are judicial activist decisions of the right. And I think it is more useful to focus on the substance of the decisions rather than, you know, whether you can label the decision activist, because everybody's an activist sometimes. Sure. Yes.
I wanted to take you back to Bush v. Gore a moment, too. And the movie Recount.
Good movie, didn't you think?
Well,
Yeah.
I wanted specifically...
It was sort of based on Too Close to Call.
Yes. Well,
I didn't write the movie or anything, but I liked it.
well, I wanted to see if you talk a little bit more about the role of Warren Christopher. And he certainly does not come out well in that film. And is there any reason to think that he came out any better in the real situation?
No. Next question? No. Warren Christopher was a very distinguished lawyer and individual who was terrifically ill-suited for the job that Al Gore gave him in the recount, which was to be the leader of the Gore forces in Florida. James Baker recognized from the moment he was sent down there by George W. Bush that this was not just a legal dispute. This was a political dispute. It involved the news media, it involved the public, and he mobilized the Republican forces accordingly. Baker did. Christopher had a much more narrow conception of what was going to be argued about, and I think Gore was less well served as a result. Yes.
I had the privilege of hearing you speak in Philadelphia several months ago. At the end of your talk, you made an interesting speculation, which was if Hillary Clinton, who was ahead at the time, became president, that she would nominate Barack Obama to be on the Supreme Court. So
you know what, I think it's really inappropriate for you to throw that back at me, because I believe accountability flows only in one direction.
Well, unfortunately, Tim Russert isn't here, so I have to do it.
Yeah, that's true. That is well put.
So my question is, if Barack Obama is elected, number one, would he nominate Hillary Clinton to the Supreme Court? Number two, would she accept the nomination? And three, would she get confirmed?
The answer is no, no, and yes. I think he's not going to nominate her for a very simple reason that has nothing to do with the drama of the primaries or the campaigns. Hillary Clinton will be in her early 60s by the time Barack Obama is inaugurated, if he is inaugurated. These Supreme Court appointments are so precious that no president is going to nominate someone older than about 52 or 53. Because these presidents want their legacies to go for a very long time. I also think that Hillary Clinton is not particularly interested in being in the Supreme Court. If you look at her interests legislatively and as First Lady, they really revolve around domestic policy, health care. Judicial issues are not what she's most interested in. By the way, not to offer a pathetic defense of my prediction or anything, but Barack Obama, if he serves 2 terms, will be 54 years old. William Howard, well, I don't think he's going to nominate himself, but I mean, William Howard Taft, when became Chief Justice of the United States after he was president, I think it's far from out of the question that that wouldn't be possible for Obama as well. I realize I'm getting a little ahead of myself here, but I just want to raise that possibility. Yes.
Can we purchase a tape of this?
Wow.
I don't know. Some people have authorized it, some haven't.
Yeah. You got to buy a book first.
Oh, absolutely. I have it.
Yeah, sure, I guess, yeah. Yes.
As an elector from Palm Beach County, and from what I hear...
Oh, from Palm
perhaps
Beach, yes.
Actually
you know,
able
we
to be-
bought, my wife Amy and I are here, and we bought on eBay one of the butterfly ballot machines. You know, we have it in our house.
Come down and we'll show you how to vote for the
They
right
put them
candidate.
up, yeah. Greta Van Susteren bought one too, oddly enough.
But getting back to the court as a whole, as if you would be an educator of the nation, and as we hear the debates and the fundamental misunderstanding of how non-elected individuals really make decisions that can overturn elected representatives, how are you trying to convey to the public, and especially young Americans, the role of the court so that we don't have the types of speeches that we heard from Wake Forest?
Well, I think you give me a lot more credit than I give myself. I mean, I think the best someone in my position can do is to talk about the court in its in a real way, not in abstractions. But frankly, one of the hardest things to explain to people is why unelected, unaccountable judges get to overturn the will of elected officials and do it with some regularity. And that's a hard question of political philosophy. And, you know, not to, I mean, the idea, and it is not entirely clear that the framers of the Constitution thought that's how it should work. But in 1803, Chief Justice John Marshall wrote an opinion in the case called Marbury versus Madison, where he said it is the province and duty of the judiciary to say what the law is. And since that time, the Supreme Court, as Justice Jackson said, they may not be infallible, but they've been final since then. And the idea is that sometimes shifting political majorities can abuse the rights of minorities. And some institution has to exist to make sure that the rights of the minorities are protected, even though they can't triumph at the ballot box, and that's the courts. That's the idea. Yes?
Mr. Toobin, I have a brief comment and a question. Loved the Nine, and I hope you'll write a sequel about the Roberts courts, perhaps contrasting it with the Rehnquist and Berger courts.
Perhaps, but no time soon.
No. Wait till we get a few more
Yeah, a few
justices
more
to
years.
talk about. The question. I would love to hear you talk about the D.C. handgun case and what that might say about what we can expect from the court in the future.
Well, the D.C. handgun case is interesting at so many different levels. But you know what I talked about when Edwin Meese came to Washington in 1981 with President Reagan. One of the things, he gave a famous speech where he talks about a jurisprudence of original intention, where he talked about how the Constitution should be interpreted how the framers of the Constitution understood it. That's the correct way you should interpret the Constitution. The meaning of the words should be the meaning understood by those who ratified it in 1787. Now, that was considered a pretty far-out idea in 1981 when Meese raised it. But if you read the Heller decision, the D.C. gun case, it is all about what the framers intended the Second Amendment to mean. I mean, the degree, and Scalia and Thomas have been the most outspoken supporters of originalism. And even Justice Stevens, who wrote the dissent, the main dissent, his point was not that this is a wrong way to interpret the Constitution, it's just that if you look at the original meaning of the Constitution, it does allow gun control. But I think that rhetorical victory by Meese's heirs is really a tremendous thing, and in many respects the most important part. Now, Roberts and Alito, while they are conservative in their votes, they have not made clear that they are fully originalist. So that's something we're going to have to keep an eye on. But, as I say, the court now depends on which way Anthony Kennedy goes. But, let Stevens go, let Ginsburg go, let Roberts go, could be let Souter go, could be very different.
You'll have material for another book.
There's always material. That's good. Yes.
What will it take to get more bipartisanship in the Senate confirmation process and more bipartisan vote instead of straight party line votes, do you think?
Well, your question assumes that bipartisanship is necessarily a good thing, which I don't necessarily share. I mean, I think the business of being a Supreme Court justice is a highly partisan thing. And I think we don't need more bipartisanship. We need more candor. We need more honest examination of what the justices or would-be justices stand for. For example, all 18 members of the Senate Judiciary Committee, when they run for office, are expected by their constituents to answer the question, do you think Roe v. Wade should be overturned? And they answer that question however they choose, and then they're elected. A would-be Supreme Court justice testifies before this group and is asked, should Roe v. Wade be overturned? And he says, well, I can't answer that question because it may come before the court. What kind of answer is that? They thought about the issue. This is an important issue. This is something that anyone who has given serious thought to constitutional law has an opinion about. But we're supposed to have our senators vote on them without knowing the answer to that question? I think that's the real outrage, not the absence of bipartisanship. Arlen Specter has a wonderful line. He says, Supreme Court justices will say as little as possible in order to get confirmed. And I think he's exactly right. But that's because senators let them get away with it. And until they stop letting them get away with it and say, we won't vote for you or against you until you answer our questions, then I think that the stonewalling will continue.
But hasn't it always been that way if you look back?
Well, not really. I mean, the one exception was the Bork hearings, because Bork had written so extensively that he couldn't really say, I don't have an opinion, because it was so obvious that he did have opinions. So I think that it has not always been that way, but it's been mostly that way. Yes?
Mine is more of a comment than a question. As a retired historian from the Manuscript Division of the Library of Congress, I wanted to point out that a number of the justices' papers are available to the public at the Library of Congress. But more interestingly, since you talked about the Gobaitis case, some years ago we persuaded William Gobaitis to give us his papers. Okay. And it's a small collection, but among the papers is a wonderful letter that is online, by the way, on the Library of Congress website, and in the manuscript, in which Billy Gobaitis, as a 9-year-old boy, writes to his school director why he couldn't salute the flag. And it's a fascinating letter in his own hand when he was 9 years old, and it's available online.
Well, and that is so true. And the story of those cases it wasn't some abstract constitutional drama. I mean, these Jehovah's Witnesses were beaten up, they were driven from their communities, driven out of their homes. It was a very scary thing for them.
They were the civil libertarians of their own time in a strange way.
Yeah, not in an unstrange way, in a
real
very
way.
in a very direct way.
But the case itself, and then the West Virginia case, the apocryphal story is that they asked Douglas why had Justice Black changed his mind between the two cases, and they asked Douglas, had he been reading the Constitution more carefully? And Douglas said, no, he'd been reading the newspapers.
That's right. In fact, Robert Jackson's papers are at the Library of Congress, and I believe we ran into each other there, where the nerds meet, at the Library of Congress Manuscript Division. I was looking at Blackman's papers, John was looking at Jackson's, just by coincidence, there we were. Yes?
I'll buy your book, so you may have already provided an answer to this one. But going back to John Marshall's point, that the court gives its opinion based on what the law says. What is the article in the Constitution or in any of the amendments based upon which the Supreme Court can decide who is elected president?
Well, I think that's a little unfair to the court. I mean, much as I don't approve of the decision in Bush v. Gore, I mean, what the court said in Bush v. Gore was that the way that the Florida Supreme Court had ordered the recount to take place violated the rights to equal protection of the law under the 14th Amendment of George W. Bush. I mean, that's what they said. Now, whether you believe that that's what they were really doing is a separate question, and what their motives really were, but it's not like they simply decided we think Bush is going to be needs to be president. They interpreted the 14th Amendment as they saw fit.
Yeah, with originalists, could they make that premise?
That's how they voted, can I say? Yes.
Because of your commentary on Justice Thomas, I want to preface my question by reminding everyone of a statement or an observation expressed a few years back by our fellow Chautauquan, Mark Russell. He said that we could save money by eliminating Justice Thomas's seat and giving Justice Scalia 2 votes.
You know, I think, with all due respect to Mark Russell, that is not accurate. That is not fair to either Thomas or Scalia. Thomas is far more conservative than Scalia is. There is a very serious, there's an opinion, I write about it in the case, in the book, called Lopez from 1994, where Thomas wrote in a concurring opinion that he really believes that much of the New Deal is unconstitutional, that the scope of the federal government needs to be shrunk way down. I was at a synagogue in New York where Justice Scalia was doing a talk, and someone asked him a very interesting question. Someone said, well, what's the difference between your judicial philosophy and Justice Thomas's? And he talked for a while, and, and he said, look, I'm an originalist, but I'm not a nut. And,
My
there you go.
question was going to be,
Oh, was that
if I
not?
may ask that now, okay.
Oh, I'm sorry. Sorry, I thought that was your question. Okay.
I wanted to ask you about the criteria used for selecting justices to the Supreme Court, because in recent years, it seems that all the candidates have to have been sitting judges.
That's a great...
But there was a time when we had Earl Warren, Hugo Black, and others who came from the Senate or politics, so I wonder if you'd comment on that.
The current Supreme Court is the first time in American history that all 9 justices are former federal appeals court judges. The court that decided Brown v. Board of Education in 1954, not one of the justices had ever been a judge on any court anywhere before. As you point out, Earl Warren had been governor of California, William Douglas, head of the SEC, Robert Jackson, who had been a New Deal official, had many jobs in the Roosevelt administration. I think under McCain or Obama, we will see an end to the domination of the judiciary. One of the things Joe Biden always says in confirmation hearings is, I just wish some of you people had run for dog catcher once. And I think that's really true. I think O'Connor added a tremendous amount to the court by having been an elected official. Why don't we take these last 3 questions? Yes.
Okay, you